Well, thank you all for being here. We're excited to talk about one of the great mysteries of life, business contracts. Hopefully, in a way that's a little more engaging and entertaining than what I think most folks are used to expecting. We are not stand-up comedians yet, mostly because I prefer to sit in a chair. And yes, that's a dad joke. Try to keep my son entertained with stuff. We got a 3.5-year-old. He is a lot faster than I am, and he is more fun, more intelligent, and that scares me for a lot of reasons that I'm sure the parents on the call can understand. My name is Sam Foreman. My colleague is Mike McPhee. We're attorneys here in Wichita. We love working with small businesses on a variety of topics, ranging from setting up entities to contract issues to commercial real estate and a variety of other topics that folks frequently encounter. Really appreciate you taking some of your time today to join us. Hopefully this will be something that is useful for you in helping your business take the next step forward. Would love to answer any questions as we're going through. Our style is pretty dynamic and interactive. And so if you've got questions that come up as we're going through the slides, certainly raise a hand or put that in the Q&A section section, and I think Mindy will be monitoring for that to kind of help us respond to those in close to real time. So a little bit about myself. Grew up in Topeka, Kansas. Moved down here about 10 years ago. Just love it here in Wichita. It's a great community. There's a lot of really awesome momentum in the city right now, and I'm excited for what lies ahead. And I promise not to talk about Century 2 today. It's one of the off-limits topics, as well as I understand profanity is to be avoided as well. My colleague Mike McPhee just joined our firm last year. Mike was on Law Journal, which is a high honor at Washburn Law School in Topeka, which is also my alma mater. He focuses his practice a lot on serving clients with a variety of business needs and also intellectual property concerns such as trademarks, software licensing, online terms of use and privacy policies and things of that nature. And just generally doing a lot of great stuff. Mike is also a professional hockey player. Which
no, I'm not.
Which you won't admit to her own, or semi-professional hockey player. He recently won a big tournament in Kansas City. And Mike, you had like a hat trick or something like that. But anyway, let's talk about what this presentation is not. It's informational purposes only, not intended as legal advice. There's no attorney-client relationship formed by this presentation. We're happy to talk to you all if you've got questions and try to provide some general answers. Anything specific, anything where you're needing some legal advice, we'd be happy to be a resource for you or point you in a particular direction. But I want to make sure that that's clear, that there's no attorney-client relationship formed here, and that this is just for general informational purposes. One other thing I do want to flag is that, obviously each of the topics we're going to talk about today, we could go spend hours and days, talking in depth about all of these. And so what we hope you'll be able to take away from the presentation is some really useful information that'll help you identify, hey, I remember hearing about that. I think this is an issue I need to look into more as you go along with your business. So. And with that, I'll go to the next slide. We're going to talk about these things specifically today. We're going to talk about employment agreements, independent contractor agreements, non-disclosure agreements, non-competes, customer and supplier agreements, and leases. If there are other topics, other agreements that you've encountered that you'd like to chat about, I'm open to discussing those in the Q&A session that we have. I think after we get through the slides. So let's talk about employment agreements. Most folks, I think, that are working in today's economy do not have a written employment agreement. They might have signed an acknowledgement of a handbook, which might create some rights and responsibilities there. They've certainly got rights and responsibilities, just from a legal standpoint, even without a written agreement. But particularly when you're dealing with important people, important risks, important rights in an employment context, I think it's really important to think about having a written employment agreement so that to the extent you reasonably can, you try to create some clarity around some really key issues. And I want to talk about a couple of those. So, you want to think about duties. What are the duties that the employee has a responsibility to perform? If this is a kind of an entry level employee, it may not be something where you need anything more than, your current job description. When you hired them, that may be sufficient. If it's, you're hiring someone who's going to run your business or who's going to be in training to take over your business, you might want to think in more detail about, have I created clear expectations about what it is that they need to do? That is particularly important when it comes to things like termination rights. And we'll get to that here in a minute. But a good description of duties should provide enough clarity for everyone to understand, here's what it is that this person has been hired to do. So you'll often see in their language like, hey, this will include these types of duties that this person in this role would typically perform for similar companies, similar industry, similar, stage of development, et cetera. Those can be really helpful catch-alls. You also often want to include a catch-all phrase on the order of, hey, this is also going to include anything else that the company reasonably asks this person to perform, so that there's not not any kind of ambiguity or a gap around if they've been asked to do different things, they get a promotion, they get whatever else during the course of their employment. You don't want any gray area around whether or not that is still covered by the employment agreement. You want to think about the term of the agreement as well. If you're the employer and you're hiring somebody, it's important to have some clarity around what the term is. And frequently employment agreements will be set up that, hey, the term of this agreement is until you get fired. And that's pretty much it. And I think that that's a helpful way to do it. Sometimes you'll see that the agreement has a particular fixed period of time, like, a year, 2 years, some other expectation. Where the employer can end up with some risk there is that if the employer has promised to employ somebody for a certain period of time, they've got to assume that they're on the hook to fulfill that obligation until the end of that period. And so then it becomes a lot more important to spell out when can that person be terminated for cause. And so a termination for cause is typically going to spell out things like, hey, they committed some crime, they did something that really damaged the company, brought a lot of disrepute to the business. They, consistently did not fulfill their duties, which is where the language about duties is particularly important, et cetera. Which is why a lot of times, I like to see, if I'm representing an employer, an at-will type of relationship. And what at-will means is that the employee can quit anytime, can be fired anytime, and there's not really a penalty one way or another if they are terminated for any reason or no reason, outside of reasons that are illegal. I can't, fire somebody for any restricted legal status, et cetera. Nor should you. You also want to think about IP ownership. If your business has any kind of intellectual property, and that could be, you're inventing things, but it could also be just this person works in branding and they're coming up with new graphics, new designs, new, slogans, other digital assets, et cetera. It's really important, I think, and it could be much broader than that. It could be business models, business plans, anything that could be intellectual property. You want to think about having some language in there that says clearly, hey, you're going to create intellectual property, or you might create intellectual property for us. That's going to belong to us as the company. There's a lot of circumstances where the company will just by default own intellectual property that the employee creates. But I think if that's an important part of their role, or if they're creating or touching anything that's really important, it's just good practice to have that kind of language in there so that you don't have any loose ends on ownership. Um, you also want to think about compensation, obviously. Are they going to be salaried? You know, is it hourly? How's that going to be tracked? How is that going to be calculated? Or is it just something where, you know, the agreement is going to provide a nod to the fact that this person's going to get paid whatever they're agreed to, you know, from time to time with the company. You want to think about what's the past practice been. How do you need to create clarity there? You know, similarly thinking about things like benefits. Do those need to be spelled out in the agreement, or is it just a reference to, hey, we're going to provide you whatever we provide to other folks? And so you'll see that negotiated a lot. You also want to think about restrictive covenants, things like confidentiality that are going to say, hey, you can't disclose any information, you can't use it for any purpose. Things like, you know, a non-compete that might be in there. Mike will be talking about those here in a couple of minutes. Non-solicitation, non-disparagement, some similar types of things in there. And then, you know, another key thing to think about in employment agreements is, are there state-specific issues that need to be considered? You know, particularly when it comes to IP ownership or restrictive covenants, and there's certainly other topics where that can be important. Not every state approaches things the same way. And so if you've got employees out of state, you certainly want to be mindful that those are potentially issues that are going to be in play. So any questions so far as we're going through?
I'm not seeing any yet.
Great, great. I'm going to go on to the next slide here. Also want to talk about independent contractor agreements. And I want to preface this probably by talking about the last point first, which I probably should have put first. You always want to make sure that people are classified correctly. And there's just a lot of factors that get taken into consideration when you're, you know, making that decision. I'll frequently hear clients say, hey, I've got these people set up as 1099 employees. Well, that's a little problematic. 1099 is for independent contractors only. It's not for employees. And if you're in a position where you think somebody's actually an employee and you're treating them like an employee, but you're trying to, you know, set them up as an independent contractor, you know, then there could be issues there. And so you just want to be very careful with that. Obviously, as a small business, you're constantly trying to balance your risks and your opportunities and figure out what's the best way to treat things, but just always be careful that you're correctly classifying folks as you're going through. You want to look at, you know, does this person genuinely control what they're doing? Or is this somebody who, you know, their hours are set, the work that they're doing is set, and everything is really controlled by the company? Not that that's the ultimate standard on everything, but it certainly is important. So just be really sensitive to that if you're trying to make sure that folks are correctly classified. So on independent contractor agreements, you want to think about, you know, similar to duties with an employee, do you have a good description of what are the services that this person's going to be providing? And is it something where you're going to have statements of work, or is it just, hey, we're going to keep this lean and mean, and we're just going to exchange emails back and forth, and it's going to say, hey, you know, I've asked you to do X, Y, Z, and you know, you're going to do it for, you know, for this rate and complete it by this time. But you want to think about, you know, how much detail do you really need to go into? I mean, the lawyer answer is always, you know, make sure you're going into as much detail as you possibly can. But that's obviously not very practical all the time. And so you want to be sensitive to, you know, what is going to create the value that you're looking to get out of that document, so you can get a reasonable description of services as you're going through. You also want to think about, what is the mechanism for doing new services? Is this something where we're just setting it up and the person's going to be available when I call and they have a project, they're going to do the project and they're going to follow the parameters? Or is it something where we're going to have a defined process, such as, you know, here's our services agreement, you know, see attached Exhibit A for, you know, our new statement of work. Every time there's a new project, we're going to do a new statement of work, and here's the process it's going to go through. A lot of that's going to depend on how substantial is the relationship and things. So you also want to think about term and termination for the same reasons. that you would on an employee agreement, you want to make sure that it's really clear, how long is this actually going to last? Is it something where we're going to set it and then we're going to terminate when we're ready and it's just going to run until it's done? Or is it something where we're going to have a defined term and then we're going to have to either have a renewal process or renegotiation process or some other mechanism where we've got to get the agreement to continue if we want to actually continue doing business. And then you want to think about, yes.
We do have one question.
Oh, great.
Somebody asked, do you have any recommendations for websites or services that have the best templates, or should we have an attorney on retainer to assist each time we need a contract drafted?
You kind of have to balance on that. You get what you pay for a lot of times on those template services. I've seen some where the product looks pretty good, and I've seen some where it just didn't make any sense at all. My general thought is you ought to at least have a good conversation with an attorney to see if you've got a good relationship there, understand what the trade-offs are between using some kind of template service versus using an actual attorney. And then make sure you're understanding what the differences are. A template service is typically going to be a self-guided legal service where you're not actually getting information from somebody who has, a lot of knowledge in that particular area, who's not going to be able to answer for you, a lot of the questions about, hey, what's customary here? What's normal here? This is a particular risk that I'm concerned about. How should I manage that? So my general recommendation is at least have a conversation with an attorney who's knowledgeable in the area, try to figure out if that's a good relationship for you. And then just prioritize, what resources are important for your business and what, the trade-offs are there. So.
Thank you.
IP ownership. IP ownership is a bigger deal with independent contractors that touch your IP than it is with employees. In terms of, the legal default for employees is often going to be that you're going to end up owning stuff that they might create that's within the scope of their work, although you still want to have it in writing. With independent contractors, it may not work that way. And particularly if you have a simple agreement that doesn't go into a lot of detail, you might have, issues where you then subsequently ask them to do something and then end up, without having sufficient legal rights to own what it is that they've created. And so you certainly want to be mindful of that. You also want to have, again, clear language about how are they going to get paid, when are they going to get paid. What you will also want to think about in terms of the services that they're providing and how they get paid is there going to be any kind of approval process for the work that they're performing? Are they going to need to provide any kind of warranty services and so on? And then again, you also want to think about restrictive covenants, that being non-compete, non-solicitation, confidentiality, non-disparagement, and perhaps some others, ways that you have, important interests for the business that need to be protected, and are those going to be appropriately protected as you're going through. So. And then we already talked about the classification issue there. So, and I'm going to hand it over to Mike to talk about non-competes. Take it away, Mike.
All right. And also, Sam, sorry, I disconnected there briefly at the end of your employment agreement slide. So if you had any questions or follow-up from me that you wanted, I apologize, I missed it if it was in a 15 to 20-second window. Okay, so non-competes. So another party from engaging in specific activities with, within a certain amount of time and a certain geographic scope. The enforceability of these are generally going to depend on if the restrictions are reasonable and if it's protecting a legitimate business interest. So these are typically very fact specific and also jurisdiction specific as to whether they're going to be enforceable or not. In Kansas, for example, a 2-year, maybe a 2-year non-compete may be enforceable, whereas in another state, and there's also this sort of inverse rule between duration and geographic scope. If the duration is longer, then it would probably require a more limited geographic scope to be enforceable, and vice versa. If the geographic scope is a lot larger, maybe the duration would have to be a lot shorter. And it's really just going to depend on the facts and the relationship between the parties. And there are also state-specific issues that arise with these. Some states don't enforce them at all. California, for example, is a state that doesn't enforce non-competes at all. So you should also keep in mind, non-solicitation and non-disparagement agreements, and non-competes and non-solicitation, non-disparagement. They can all be baked into other agreements as well. They're not necessarily their own separate agreement. You can have these in employment contexts or independent contractor contexts, or even buyer-supplier sort of context. So non-solicitation, generally, these agreements prohibit a party from soliciting customers or employees from the other party for a certain amount of time after the termination of the agreement between the parties. Non-disparagement is generally you can't say bad things about the other party. And Sam, if you have more to add on that part, go ahead. But
yeah, I think on non-disparagement, what you're really trying to do is protect the brand equity. You're really trying to protect the reputation of the business. Most folks are probably familiar with the term defamation. Defamation is where somebody lies about the business or about the people associated with the business and causes damage. And so, that might be in writing, it might be verbal, it could take some other form. Those are really, really difficult claims to win, to prove, because you have to prove damages. And there's just so many variables out there in that kind of an analysis that, it's just, they're not great cases. But if you've got somebody who has a non-disparagement that clearly says no public, disparaging statements or negative statements or whatever, and then you have somebody on, YouTube or, out in public, in a public setting saying things that are negative, like, hey, fact one, it was in public. Fact two, it was negative. And then we're done and we've got a breach of contract claim. And so that's, can provide some more protection for the company. One other thing I'll add on non-solicitation is that these can be broad or they can be really narrow, but really what they're trying to do is protect the key relationships for the company. And so they may not just be trying to take somebody away from doing business with the company, but they could also be trying to hire somebody, trying to get somebody to quit, trying to sell competing products to somebody. And so there's a number of different forms that can take as well. So I'm going to go on to the next slide here. Did we hit NDAs? Sorry, I skipped this one. Mike, can you talk us through NDAs as well? Okay. I promise everyone I know how to computer most days. Hey, Mike, I'm having a lot of trouble hearing you. Can you check your internet connection?
Yeah, I actually just disconnected too. So hope.
Yeah, still having trouble hearing you, Mike. Well, while Mike gets that sorted out a little bit, let me talk a little bit about NDAs. So this is, sorry, give me just a second, folks. try to sort out the technical difficulties here. I'll take this slide for right now. Just figure it out. We're gonna figure it out. So non-disclosure agreements. Oh, there's Mike. Mike, can you hear me, Mike?
Back? Yeah. Can you hear me?
Yeah,
Sorry
I can
about
hear you. All right, take it away, Mike.
Okay, so NDAs, I don't know how much of what I said was caught, but NDAs largely, you can have mutual NDAs or one-way NDAs. A mutual NDA protects information that is disclosed by either party to the other party, and then a one-way is just one party to the other. And you typically see one-ways maybe more in the employment context, as the employer might want to protect the information they're disclosing to their employees, maybe not so worried about information that the employee discloses to the employer. But and then so a good NDAs typically have two parts to them. There's the confidentiality piece, and then there's the non-use. Confidentiality is you can't disclose the information that I provide you to other people, other third parties. And non-use is you can't use the information internally. If you don't have the non-use piece, but you just have the confidentiality piece, there's potential for a gap there where, say for instance, you're in a buyer supplier arrangement and you disclose information to the supplier, and you don't have a non-use, perhaps they're not going to disclose the information because you still have the confidentiality piece, but they might use that information to their own benefit. So the NDAs hopefully restrict that piece of it. When drafting NDAs, you want to be careful about what information is included in those. You want to include a pretty broad definition of what constitutes confidential information. So it captures all kinds of intellectual property, maybe even conversations that the parties have that should remain confidential and only between the parties, and other things as well, copyright, other sort of work products. So you want to make sure that all that is captured and protected under the NDA. In terms of term and termination, you generally want these to last past the termination of the agreement between the parties. Perhaps the agreement only lasts 3 years, but you might want an NDA or the confidentiality provisions to survive perpetually. And on the flip side of that, maybe you want clear ways of getting out of the NDA. Maybe you don't want to receive information forever from the other party and have an obligation to keep that confidential. So you just want to be mindful of these sort of things when drafting NDAs and entering into those. Sam, did you have anything to add on that?
In terms of the identification of information, I think, one of the things you want to be really sensitive to is making sure that you're able to fulfill on your obligations. And so there's a number of different approaches that agreements will take. One where it's just, hey, anything I disclose to you is confidential and you've got to treat it, as such. I think there's another approach where, people have to mark it. They have to put some sort of like, hey, this is confidential information on the document, on the email where it's disclosed, et cetera. And so there's a lot of different ways to do that. If I'm the party receiving the information, I want really clear markings. I don't want to have any ambiguity around what's actually protected so that I can comply with the agreement. If I'm the party disclosing the information, if it's a sizable amount of information, I want to try to limit that obligation because I don't want to have to be constantly worrying about, did I mark something appropriately? And so there's a number of different ways to try to do that. then you've also got verbal conversations or observations that people have where, you need to make sure that those are protected as well. And so sometimes the agreement will just say, hey, it's in whatever form, that could be in person, it could be, verbal, it could be, written, whatever. And sometimes it'll say, hey, and by the way, if this occurs, if it's verbal or if it's observational, then somebody has an obligation to send an email to say, hey, this was confidential, here's the description, etc. You always want to be sensitive to that if you're the disclosing party, because there might be information you really don't want to put in writing. And that was the purpose of describing it verbally, so that somebody else who you want to do a deal with understands what's going on, but you don't have to put it in to a format where it might be used improperly. And so those are just some things to keep in mind on that one specifically. Back to you, Mike.
Thanks, Sam. In terms of, ownership, destruction, and return, at the end of a business relationship or whatever else, you may want to require the other party to return or destroy any confidential or any records of any confidential information that you provided to them. That's mostly to protect, not necessarily them purposely disclosing or using that information, but perhaps even if that information is accidentally disclosed to a third party or brought up in some other way, you don't want that out there. So oftentimes you'll see these sorts of provisions, including a destruction clause that requires the parties to destroy any confidential information at the termination of the agreement. Sometimes too, you'll also see provisions saying that the parties can keep one record of each item, just to prove compliance with the contract's terms. I think that's all I got on that, Sam.
Awesome. One other reason to specifically address ownership is that sometimes the party that is evaluating the transaction and receiving the information might do something with the information that then proves to be economically valuable. Like they might run it through a process or system or something else and then create something new. And so having something in there that at least makes it really clear, hey, I own this, and anything that's created using it can be helpful. So, yeah. We talked about non-competes, customer and supplier agreements. On in-person things, it's just a little easier to say, hey, show of hands, who signed one of these? So customer and supplier agreements, I'm going to talk about these just kind of together, both in terms of time, but then also just because the terms sort of mirror each other depending on which side of the deal you're on. You want to think about, is there, and this is, you'll see a similar theme here with like independent contractor agreements and even to a certain extent with employment agreements. Do you have a clear description of what it is that needs to be provided? Is it clear what are the goods and the services? Do you have clear timelines, delivery dates, condition? Are there warranty obligations? These are all things where if these are important, you want to make sure that they're put in writing and they're spelled out appropriately, so that you've got something where you can point to and you can say, hey, listen, I know I agreed to buy, widgets from you for $100 grand. You made faulty widgets, so I'm not going to pay you. Or you didn't deliver on time, and our contract says that you had to deliver by this date, or I don't have to pay you. You didn't deliver, so here's your stuff back. I don't have to pay you because it was late and it's too late for my job now. You want to think about change orders in that process. A lot of times we're dealing with projects where there's a lot of variables out there and you don't know exactly how many you need, and you want to try to bake in appropriate flexibility. And so that's why a lot of times, especially when it comes to services from vendors, you'll see rates based into it, or a range of, hey, as long as we're within this range, this is what our fee structure is going to be. This is what our timing is going to be. Once we get outside of this, we're going to have a new setup. You want to think about whether or not there's any kind of testing required. If the goods are particularly sensitive, or if there's regulatory requirements, if the services are, for example, somebody's making software, et cetera, you might want to think about, is there a testing component that has to be completed before the person who's providing that has been considered to have completed things? And then is that something that you pay for, or who pays for it? What happens if it comes back and things are insufficient, et cetera? You want to think about delivery and acceptance. Has this been spelled out clearly enough that we all know, here's when it's due, here's what the process is, where I, as the customer, for example, have the ability to determine whether or not the supplier has fulfilled their obligations, and then I can go on to the next step and determine whether or not I'm obligated to pay them, or whether they have additional obligations to fix something in the process. You'll see a lot of times that the contract will say, hey, I'm going to deliver it to you as the supplier, I'm going to deliver it to you as the customer, and if you don't object to it within 30 days or whatever, you're deemed to have accepted it. And so if you're the customer and it's something that's important, you really want to track that and figure out, make sure you got it on your calendar so that you've tested things, you've determined whether or not you have any rights to say, hey, this isn't what you were supposed to provide, so give me my money back, or I don't have to pay you, take this back, etc. You also want to think about warranty work. It's one thing if you're going out and you're buying something that's you can get off the shelf somewhere. It's another if you're getting something custom, or something that's particularly sensitive, or that's service-based, and thinking about, are we going to bake into our contract a warranty obligation? So this has got to perform, this has got to hold up for X number of days, here's the warranty that's going to go with it. If you're buying something for resale, that warranty can be really important. And the terms of that warranty and its assignability can be really important, because a lot of times, you as the customer will want to be in a position to say to your customer that you're selling it to, hey, here is, this software, here is this, here is this product that I'm selling to you, and it's covered by, 1-year warranty, a 2-year warranty, whatever it might be. And then being able to know that you can rely on the person that sold it to you in order to, fulfill on that warranty if you need to. Those warranty terms, that warranty work's important to spell out so that it's clear, here's the dollars I'm paying for it, here's what I'm getting, and so that you don't have any ambiguity around what is that obligation. It's one thing to say, hey, the supplier has to provide warranty work. It's another to say, hey, the supplier has to provide warranty work for free. So just want to be aware of those, making sure that those terms are clear. And then payment terms. Is there a deposit up front? Is there a payment that's required in order to receive the goods or to have the services completed? Is there an escrow holdback of some kind, or some kind of payment that's provided when the goods are due? Is there interest that's required? You also want to think about taxes. Who's responsible for paying any taxes or fees on this? If there's import-export issues involved, and I think that the KSBDC and other organizations have good workshops on import-export issues. You certainly want to be aware of those as well. Who's going to have that responsibility to make sure that it gets from point A to point B, and to pay any fees associated with that. You also want to think about term and termination, how that works. This gets a lot more complicated in a customer and supplier relationship, particularly if you might have like a master services agreement or something similar covering the sale of goods, because you may have work in process. And so if you've got a termination right, I think you really want to have something clear that says, just for the benefit of both parties, here's what the effect of termination is. If I am terminating because the other party has breached, then if I'm the supplier, I want the customer to owe me money and to have to pay me for my damages. And so being able to try to bake something into the contract that provides some clarity around, here's how we're going to calculate that, can be really helpful, so that then you're not, spending as much money on attorneys to go back and forth to figure out what the actual damages are on that particular item. If you're the customer and you're terminating for breach, You'd probably like to have something in place that says, hey, I'm terminating because you were late and I lost the job or whatever. I'm entitled to damages, but also I don't have to pay you for anything you haven't, delivered and completed performance on yet. So that you've got some protection there and you're not stuck with, well, I didn't get what I needed on time and I have to pay that supplier, which can be a really, depending on your business and the dollars involved, can be a really unpleasant position to be in. So be thinking about those issues and the scenarios where termination might occur, and then also be thinking about termination for convenience. If somebody has the ability to just pull the plug because they feel like it, that probably ought to work differently than if somebody is terminating the agreement because they, just didn't have, or because of the other party's breach. You also want to think about, in certain circumstances and really important contracts, especially, if somebody files for bankruptcy, do I have a termination right as well? Because that just opens up a whole different ball of wax in terms of issues. Any other questions so far? Okay, I'm gonna keep going here. Mike, do you have anything to add on the customer and supplier agreements?
Nope.
Okay. I am going to put in a plug for In Spirit Kombucha. It's good stuff. Let's talk about leases. So first, a sort of a complaint about attorneys. I've seen so many different forms of leases, even just working in Wichita, that they're just kind of all over the place. I've seen leases where, and of course everybody does it differently and there's good reasons for it, but I've seen spaces that have not kidding, a 60-page lease for something that has rent of like $5,000 a month. And it's small print, it's legal length paper, just includes all kinds of gotchas and things, and it's just arcane. And I don't like that style. I much prefer that if somebody's got a simple, straightforward lease, that they have a simple, straightforward document that reflects that. But of course, everybody's got a different approach to it. Leases are often, for a lot of folks, going to be one of the biggest risk centers because location is important to their business, and that physical space specifically is important to their business. It's expensive to move, it's expensive to get kicked out, etc. But then also that there are other attributes of that specific space that you want to protect. And so you want to be thinking about what do I really value about this space that I as a business am going to occupy that I need to make sure I'm able to protect. And so a couple of those examples, I'm going to skip ahead here. Well, I'll talk about those when we get there a little bit. Think about term and termination at the beginning. You want to know up front, how am I going to get out of this? Or how long can I be here? Am I going to have good renewal options? How long am I going to be entitled to stay in this space? So you can decide, how much are you willing to pay to build out your space if you've got to do tenant improvements, or how much rent are you willing to pay and how much risk is your business going to take? I think the shortest I've seen a commercial lease go for is, sorry, give me just a second here, is about 2 years, maybe 1 year in a real special circumstance, but more commonly the initial term is going to be about 3 years or 5 years, sometimes 7. And then often that you'll see renewal options, and it's pretty common to have at least 2 renewal options so that somebody could have the tenant could have the right to stay in the space for up to 15 years. And I think that's really important as the tenant to really try to make sure that you've got the ability to dig in and become a part of that space for an extended period of time. To the extent that's a valuable part of your business. I mean, if it's just, nope, we could move tomorrow to a different space and it wouldn't hurt us at all, then, don't spend a lot of time thinking about that. Termination is important. Obviously, you want to know, what are the things that the landlord can do to kick me out? obviously non-payment of rent, pay your rent on time, pay it in full. When you've got a landlord that you want to ask about reputation as well. Is this a landlord that's going to be looking to stick it to me? What's their plan with the space? Just so you have a sense of some of the intangibles at play. If you're in a space that's near Kellogg or any other major street that might get expanded, you want to think about a whole different set of issues. Could the city or the county or somebody else come along from a governmental standpoint and say, that land looks nice, I'll have that. And then they use a legal process to try to get the land, or they buy it from the current landlord, and then they take part of the land. What happens to your lease and your space? Your lease should include some language that at least at a minimum lets you out, but it also would be nice if it includes some language that says, oh yeah, and I can make a claim too, to say, hey, I've got these moving costs, you got to pay me for it. So you want to be really careful about those kind of things. You also want to be careful about, what happens if the property is damaged? What are the landlord's responsibilities to repair the property? What time period? How much is damaged? Is renovated during that process? So a lot of those are customary things to include, but they're not always included. Or the timelines involved might be so or the thresholds might be so generous in favor of the landlord that you as a tenant might be sitting there like, okay, thanks that my rent was now abated 50% because half the building burned down, but I can't use any of the space, and you don't have an obligation to fix it for 6 months, and I'm still stuck in this lease for 6 months, without any ability to use the space. And so, that'd be fairly rare to see that, but I have seen it before, and so you want to be really careful about those kind of things. You want to understand whether or not what you're getting with your lease. Is it full service? Is it gross? Is it triple net? And what those, you'll see people describe it differently. And sometimes they'll call it one thing, but then there'll be carve outs. And so you always want to make sure, even if somebody has presented it in a realtor's package as one thing, make sure you read the lease to understand what does this actually include. And so that you've got an actual understanding of whether or not it lines up with your expectations. A lot of times full service or gross leases are going to include things like utilities, taxes, maintenance, insurance. They're going to just wrap up all of it into, here's the price you pay. Triple net leases are, on the other hand, are going to say, hey, I'm the landlord, you're going to pay me X. And then when taxes come in, when insurance comes in, when maintenance occurs, I'm going to send you a bill for those items, and you're going to pay me for those items as well. And so when you have a triple net, a lot of times as a tenant, you'll want to think about, well, can I put a cap on it? Can I create some more clarity for myself so that I don't get stuck with everything? You also want to think and understand, if you're in a multi-tenant property, how does that number get calculated? If the landlord can just, if I'm the only tenant there, can the landlord say, well, your share of all these costs is 100%? Or is it based on, number of tenants? Is it based on square footage, relative square footage, et cetera? And so just be really careful and sensitive to those so that and can budget appropriately. Here's what I'm stuck with. On payment terms, you want to make sure that you understand where are these terms going to increase. Is this something where I have a lot of clarity around my rent is going to be X dollars per square foot, during term 1, during renewal term 1, it's going to be, this other number, during renewal term 2, it's going to be this other number. Or is it something where, hey, every year we're going to look at the consumer price index and we're going to make an adjustment. So you want to be sensitive to those, understand how those work, so that you can try to have some more clarity around some of those things. When you also might want to think about purchase options and rights of first refusal. Obviously, if you're somebody going into a strip center and you've got one spot out of 25 in the space or in that property, and there's a lot of other people in there, and you just it's not that big a deal, it's going to be really hard for you to get a purchase option or right of first refusal on, or even a right of first offer on the property as a whole, or even that particular unit. That'd be really rare to get. But if you are the anchor tenant, or if you are the only tenant, or the main tenant in a property, then your bargaining power could be bigger. And as you're thinking about the future of your business, you might want to think about, gee, would I like to own this someday? And is that something I could pick up, a contractual right to do from the owner? I want to talk about the distinction between the purchase options and the right of first refusal. The purchase option is going to give you a right under certain circumstances to go to the landlord and say, hey, I'm ready to buy, here's the check, let's get this done. The right of first refusal, on the other hand, is going to say, I'm the landlord, I've got an offer, here's what it is, I've got to come to you, the tenant, and say, hey, I want to sell to this person, do you want to buy? If not, I'm going to sell. And then you have that right as the tenant, if you've got appropriately drafted right of first refusal, to say, yep, I'm in, I'm going to take it, and go from there. A lot of times, if your goal is to get the property long-term, or at least have the right to get the property long-term, you really want to think about having both. If you have a purchase option and it doesn't have some sort of requirement that they can't sell without first offering it to you, or better yet, you have a right of first refusal, there's a scenario in which they could sell it to somebody else. Your purchase option may or may not survive at that point. That's very fact specific. And you may have a much more difficult time dealing with somebody you don't know, you hadn't planned on going into business with, than you would, dealing with somebody that you had that relationship with. And so you want to think about having both of those, and understanding what the difference is. Similarly, if you just have a right of first refusal, that's not necessarily going to put you in a position where you can control whether or not you buy that particular property, because without some third party saying, hey, I'm going to buy it, and the landlord saying, yep, I want to sell it to him, most of the time you can't, you're not going to be in a position to trigger that right to purchase that. You always want to be aware of what are the big ticket items in the lease that the landlord wants you to pay for. I have seen small leases where the landlord wanted to require the tenant to pay for an elevator. I mean, that's like $100,000 expense. To be very expensive. Certainly something you want to be aware of. Sorry, give me just a second. Yep, I'm on a webinar. Can I get you in a little bit? Yep. Oh, okay. Yep, just take them from him, tell them all. Yep, sorry. I'm back now. We had a very important delivery of more paper to our office. So you want to look out for the big ticket items, and try to quantify what those expenses are. If it's not something that you have a really good firsthand knowledge of what the expenses are likely to be, and even then, you always want to understand, what is this actually going to cost me? One of the ones I've seen that I see get negotiated a lot is HVAC. So the heating, ventilating, air conditioning system. And those can be extremely expensive. And you don't want to end up in a position as a tenant where, or at least you'd generally not like to be in a position as a tenant where you have to pay to replace that. Or if you are required to sign a lease just because that's the only thing the landlord will sign, that requires you to pay for that, you want to think about, are there alternatives? Like, hey, I want a rep and warranty from the landlord that this is a new unit, so then if it breaks down in a month, I can go up there and be like, hey, you lied. It's 20 years old. I'm not going to pay to replace it, or that it's been maintained properly. One alternative to that I've seen work a number of times to replacing the unit is that the tenant will pay for a maintenance plan. The tenant will pay to maintain the HVAC and keep it in good working order, which, if you had a responsibility to replace it, you'd probably want to do that anyway, because you want to stay out on top of that as best you can. Another one that's sometimes related, depending on the property, is a boiler, a roof. Goodness, some of that stuff gets really expensive. You want to think about making sure that it's clear, like, hey, if insurance is paying for this, I'm not paying for this. But then you really want to understand, what are your insurance obligations? If insurance says, hey, it was your responsibility to insure these things, you didn't insure them, you may be stuck with the bill that you could have paid insurance for instead of having that happen. I'm reminded of the massive hailstorm we had, I think at some point last year, where, man, just a lot of damage, a lot of roofs replaced, a lot of rooftop units replaced, et cetera. So got to be aware of those things. Think about your business and what's important to you, and make sure it's in the lease. If a particular kind of access is important, I'm going to ask you all to raise your hands, and I'm just going to nod and pretend that I see them. I assume everyone here is familiar with K96 in Greenwich. With all the construction that's going on out there, you had a number of places where, people from a variety of different, angles could easily see particular businesses. And now that certain out parcels or additional buildings have been constructed there, the ability to access, the ability to see different buildings is becoming more difficult. And so that's called a line of sight issue. And so you want to think about, if you're getting a space where the landlord could realistically block visibility of your space, and visibility is important, you might want to think about having something in your lease that says, you can't block my space. Or at least here's the angles, here's where you might put it out. And better yet, attaching a exhibit that says, here's where you can build stuff, landlord, and it can only be this tall, so that you've got good line of sight, because that location might only be valuable to you because people can see it. You want to think about parking spaces. It'd be nice to have those signs that say this parking is only for XYZ space, making sure that those are included, so that then your customers can roll right up to the door, park and get in and get out, and not have to deal with, having your neighbors who just happen to have their busy hours start, 30 minutes to an hour before yours, have all of their customers filling up your primo spots and then losing business as a result. We've already talked about renewal options. Be mindful of use restrictions. Frequently, the landlord is going to carve those up and, make it real clear that your current business is okay. You want to think into the future of what does my business plan look like? What all am I going to get into? And how do I make sure that I've got appropriate rights to do what it is that I need to do in order to execute on my business? So a lot of times I'll see in their language about, we're not going to do anything that could interfere with anybody else's use. We're not going to do anything illegal. Obviously, don't do anything illegal, but depending on the nature of your business, you want to think really carefully about what could I be doing that might potentially interfere with somebody else's business? And would it be a normal, customary part of my business, to where I'd like to have something that specifically says, hey, that's great, but I'd really like to make sure that we specifically say, my business includes these 3 activities, so I'm going to keep doing these 3 activities, and that's not going to be a problem. So, in just a second here, and be aware of personal guarantees. Personal guarantees, you'll see those a lot with smaller businesses that are leasing space. You want to be aware of those and make sure that you're on top of that as a business owner. You probably don't want to be in a position where you have to sign a personal guarantee if you can avoid it, but sometimes there's just not a way to avoid it. And so you just want to be aware of that. Understand what it is, what it says. Some folks will think, well, hey, I'm an LLC or I'm a corporation. I have limited personal liability, so I'm not on the hook for anything. Well, if you sign a personal guarantee with your business, that is a personal obligation, and whatever the terms of that are, you're going to be stuck with those. So you just need to be aware of that. So give me just a second. I think that's our last slide. So yeah, appreciate your all's attention. I think we're on track from a timing perspective. We're happy to answer any questions you all have. Happy to chat some more about anything we didn't cover that you'd like to discuss.
I'm not seeing any questions so far.
Great. Happy to give it a few moments if that's useful. And Were there any questions that folks had or any contracts that we didn't discuss that folks would like to have some more information on?
We do have one question that popped up. Somebody asked, how do I get out of an NDA?
That is a great question, and that depends. I think the first thing to look at on that is, does it have a termination provision in there? Does it have a defined process, or is it something where you've just got to wait it out? If it's just if it has a termination process, then you follow the termination process. If it doesn't have a termination process, but it has a defined term, you might have to wait out the term. And outside of that, you might be stuck trying to look at, litigation options, or going to the other party and saying, hey, I need you to let me out of this NDA. Can we put something in writing that says it doesn't apply anymore? So, yep. Happy to talk about that more specifically if you'd like to reach out to us offline. One thing to be mindful of in a termination context is what sort of obligations continue to survive the agreement. And in an NDA, you should assume that there might be a lot of stuff that survives. And so you just really need to be aware of that, really need to be mindful that you may still have continuing obligations that you need to really carefully comply with.
Somebody asked, can I sue my attorney if he writes a lousy agreement for me?
Am I your attorney? You might be able to. I think that's something you want to be really careful about, of course, because if you need to use attorneys regularly, if you've got a track record of suing attorneys, you might have other attorneys that are like, I don't know if I want to work with you, particularly if it's something that they feel like you should have worked out with your former attorney. So there might be circumstances. The short answer is yes, there might be circumstances where you can sue your attorney if they wrote a lousy agreement for you. But that's something very fact specific that you'd want to be really thoughtful about whether or not that's something you want to do. The other aspect of that is thinking about, what are your damages? What's the potential, risks and reward scenario for you there? But short answer is that maybe you'd be in a position. It's a very fact specific question. So.
Okay, that's all the questions I see so far. I don't see any others.
Great. Well, thank you all for your questions. Feel free to reach out to us if you got any other questions, and happy to try to help however we can. Thank you all. Thank you for your time.
Thank you.
Appreciate it. Bye.
I think there was one more question there. Do we do trademark work? And yes, we do.
Yes. Yep, that is correct.